Lawful presence? What is he talking about? Due process? What is he talking? He's had multiple judges. The government's argument that the Judge Zinnes order improperly directs Trump to engage in international affairs is inaccurate. She's not telling you how to run your country. She's not acting like the president, refusing to return a lawful permanent resident or even a natural-born citizen. First they came for the illegals, then they came for the lawful permanent residents, and then they came for us. The Supreme Court steps in. In the final hours, we had a deadline scheduled for tonight, midnight, 11:59 to be more specific. Judge Zinnes, who we've talked about before, this woman seen here, who was appointed by Barack Obama, who was a political appointee, who has no prior judicial experience before being appointed to the bench, used to work for a liberal law firm. In fact, they sued police for police brutality. Maybe MS-13 is not that big of a deal for her. Maybe it's more clients for her law firm or something. But she was a public defender at one point, then went into private practice. And in her writings, she kept saying these things, and we're going to see this pattern emerge today, where they keep saying no due process. And he was thrown out without anybody taking a look at it. And all these other fictional platitudes that they say are reality when in fact they're not. And so we're at the Supreme Court now, but we've gone through a lot to get here. And so here's just a quick summation that we assembled to show us where we are. So Abrego sued Kristi Noem originally. She ordered, this Judge Zinnes, ordered him back by tonight, 11:59, the date of this recording. Trump filed an appeal, requested a stay. That was denied, and now we're at the Supreme Court. Now the Supreme Court has come out and granted the stay for now. Here is what John Roberts wrote. All right, listen, clock's ticking. Almost 11:59 here. He writes, all right, upon consideration of the application of counsel of the applicants, which was Trump, it is ordered that Judge Zinnes's April 4th order that was returning Garcia Kilmar, who is this guy, Kilmar Garcia, suspected MS-13 person, adjudicated non-bondable and adjudicated as having failed to appear for multiple court dates for traffic violations, but you wonder why he doesn't want to show up to court, you know? So he didn't show up to court, never applied for asylum in the multiple years that he was here. Then as soon as he was about to get deported and it was held non-bondable, then they're like, no, asylum, because my mama's pupusas are under attack in El Salvador. All right, so now he's gone. And what John Roberts just said, all right, that order that was from the judge to fly him back into the country is hereby stayed pending further order of the undersigned or of the court, from John Roberts himself or from the Supreme Court. It is further ordered that a response to the application be filed on or before April 8th by 5 p.m. So the lawyers representing Kilmar, suspected MS-13 gangbanger, is now going to respond by tomorrow evening on order of the Supreme Court. So how did we get here? Okay, now it was a very precarious position up until this point, because as you can see, here is what Trump filed originally. So we got the order from the judge. The judge said, Trump, this is unbelievable, unconstitutional. You made an error. You deported this guy and you got to bring him back. So then they went, this is Trump, they went to the Fourth Circuit Court of Appeals and they said, all right, listen, this judge is nuts. Court of Appeals. Late Friday afternoon, Judge Zinnes, federal district judge, ordered the United States to force El Salvador to send one of its citizens from MS-13 back to the United States by midnight on Monday. That's the night. If there was ever a case for an emergency stay pending appeal, this would be it. They said Kilmar Armando Abrego Garcia is presently in El Salvador being held by their government. The United States does not have control over him or the sovereign nation of El Salvador. But nevertheless, Judge Zinnes and her injunction commands Trump and Kristi Noem to somehow accomplish Abrego Garcia's return to the United States in give or take one business day. Now that order from this judge is indefensible. Foremost, it commands Trump to do something they have no independent authority to do. They can't make El Salvador release Abrego Garcia and send him to America. That's why plaintiffs did not even ask the district court for an order directing his return. They didn't ask that, right? The people who were suing on behalf of Abrego for his return. Even they admit, they say a federal court has no jurisdiction over the government of El Salvador, and they can't force them to come back, to bring him back. That's all that's needed. No federal court has the power to command the executive branch to engage in a certain act of foreign relations. You can't mandate that we go and interface with some foreign power and do something some way, because that's an Article 2 power. You're a judge. You're not the president. That is the exclusive prerogative of Article 2. It is immune from any superintendence by Article 3, the courts. But that is exactly what this Judge Zinnes is doing. Indeed, it's the only thing it does. It requires Trump on the clock to try to force a foreign country to take some discrete action. That sort of Federal Rules of Civil Procedure diplomacy, the FRCP, is simply intolerable in our system of government. You're trying to force us via injunction to go engage in foreign diplomacy. Yeah, that's not how the Constitution works at all. Nice try, though. But those are the most pressing defects with this judge and her order. But they are by no means the only ones. As fundamental, the judge entered its order without jurisdiction under the immigration laws. She's just making these decisions. She has no authority. In all events, they failed to carry their burdens even on the equities. Okay, so even if like the law doesn't apply at all, immigration laws, jurisdiction, standing laws, all those, minor details that the Democrats don't care about and the blue appointed judges don't really mind. If you forget about all those things, even on the equities, like, should we just like keep this dude here or not? They're like, no. Among much else, Abrego Garcia has been found to be a member of a designated foreign terrorist organization called MS-13. Now, given that status, he has no legal right or basis to be in the United States at all. Okay, there was a finding to that effect. That's enough. And more to the present point, no right to withholding relief under the INA. Now, the public interest obviously disfavors his return. We're not importing terrorists now, let alone a slapdash one conducted as a result of Judge Zinnes just on Friday night saying, I can't believe it. Absent this court's immediate intervention, Fourth Circuit, though, defendants will be ordered to engage in breakneck foreign policy at the direction of a federal district judge. This is untenable. Accordingly, Trump respectfully requests an emergency stay. And given the importance of this issue and the short time frame that Judge Zinnes imposed, we ask for a stay. Thank you. So then this went up to the Court of Appeals, Fourth Circuit, and they turned around and they said, no, you're not going to be granted that at all. Here's what they responded with. They said, all right, from the United States Court of Appeals for the Fourth Circuit, they say, upon consideration of Trump's request for a stay pending appeal and an immediate administrative stay, so kind of two separate things. One's like, can you just pause things while this appeal is pending one set of rules? Then you think of like the immediate administrative stay as like a TRO kind of a thing. So in other words, they'll grant TRO. Somebody comes in, they're like, Trump said he was going to do a bad thing sometime in the future. They're like, oh my gosh, the whole country is blocked from that. They melt down over it. It's kind of the same thing. It's like, you want to preserve the status quo, right? In this case, they don't ever do it. If it's injunctioning or staying Trump, carte blanche, do whatever you want. But if it's a stay on the lower court's injunction, staying Trump, can't do it. Sorry. So the court denies the motion. Now that is the very, very brief opinion from the court, but they then did give us some concurring opinions from these judges. And let's just break these down before we get into Trump's appeal. Okay, so this was applied to the Court of Appeals, rejected very quickly. Here's what the rejecting judges wrote. They said, all right, the panel unanimously agrees that the district court's order from Judge Zinnes requiring the government to bring back Hilmar from El Salvador no later than Monday at 11:59 should not be stayed. And so the government's motion is denied. Here's what the judges write. This is Supreme Court's next. John Roberts has issued the stay. So they just got rejected. John Roberts granted a stay. They said, no, unanimous. They all lost. And John Roberts had to come in and say, hey, dummies, morons. Okay, we'll stay it. You should have probably, but we'll stay it now. So the government's motion is therefore denied. Bunch of losers. Now I write to explain my loser view. He says, the United States has no legal authority to snatch a person who is lawfully present in the United States off the street and remove him from the country without due process. So right now, this judge has just gone nuts, right out of the gates. Nobody's claiming that, by the way. But here's the problem. First of all, he got plenty of due process. And secondly, he was not lawfully present in the country anymore, okay? Just because Joe Biden said that all gangbangers and terrorists can come in and do whatever the hell they want in this country for 4 years, doesn't mean that's the current interpretation by the current executive branch. Everybody in the country illegally had plenty of notice. Get out! They didn't get out. The status has changed. Now we're looking for gangbangers and MS-13 members and Tren de Aragua, and there's dad's home, okay? Someone's home. So lawfully present was an old interpretation. Lawful presence? What is he talking about? Due process? What is he talking? He's had multiple judges. Now, in this most recent event, right, the Trump administration, they didn't just pick him up and drop him out of an airplane. And we know that because people are suing on his behalf, and they have been basically suing, not just filing a habeas petition elsewhere where he was originally detained. But let's go back. The idea that the federal government now, after having deported this dude, is powerless, they say, is unconscionable. So Trump cannot claim that. They say, here's the background on this guy. Court of Appeals from Fourth Circuit writing. They say, Abrego Garcia Kilmar, they always like to leave that first name off, Kilmar, leave that one off, is an El Salvadorian national who has been lawfully present in the United States since 2019 when he was granted withholding of removal to El Salvador. Now, I think that they are conflating that, probably intentionally. Granted withholding of removal to El Salvador is not the same thing as being lawfully present under, especially when you're in sort of this semi-lawful status. Now, they say he's got no criminal history, don't care, never been charged with a crime in the United States, okay, again, don't care, or El Salvador or any other country. Now, on March 12th, agents with ICE came in and took him without authority. Although ICE agents told Garcia that his status had changed, that that was not true. On March 15th, and what the government has conceded was an administrative error, they then flew him out. The error was the country, not the removal. So then he was placed in El Salvador at CCOT, Supermax Prison. The government undertook this action pursuant to an agreement with El Salvador. The U.S. paid El Salvador $6 million, hold these people for 1 year. So then on March 24th, Abrego, along with his wife and others, filed a lawsuit in Maryland. And let's see when he was ultimately removed, if they tell us. On March 15th. So then they came around, so it took them a while to find a lawyer. Then they filed a lawsuit in Maryland. They sued Kristi Noem and some others. Now, the complaint asserts 5 claims for relief, which is they violated the INA, and we're going to hear from the wife in the next segment. Violation of procedural due process, meaning you removed him too quickly. So they violated immigration rules, which said you can't remove him to this location. Constitution, substantive due process, and the APA, always. And we saw what John Roberts did with the APA, not John Roberts, but the Supreme Court did earlier this week. John Roberts sat on his hands. And then they issued a writ of habeas corpus, right, which is the real claim of all of them. Now, they tell us, Abrego Garcia moved for a TRO. His lawyers, they wanted to force the government, remove Garcia from CCOT and bring him back and then stop paying Naive. They held a hearing on this last week, April 4th. The same day, Judge Zinnes came out and granted it. They said, bring him back here by 11:59. In response, the government filed an appeal, and here we are. So the Court of Appeals tells us the following. They say, well, I begin with Trump and Kristi Noem's second argument because our first act must always be to determine whether we have jurisdiction. We're just a court in Maryland. It's not immigration court. It's not a writ of habeas for where he was last detained, let's say in Texas or something. They sued in Maryland, and they went right to a judge that they probably know and love, who was appointed by Obama, who has a history of suing cops for being bad. But as the Supreme Court has made clear, the law says we do have jurisdiction. Now, the question is whether the government is going to win because Abrego was removed pursuant to a lawful order of removal. Now, the government says there is no doubt that a removal order was issued against Abrego. The government says that. And there is no doubt that Abrego was removed pursuant to that order. But they say the government is wrong, the Court of Appeals. While an order of removal is separate from and antecedent to a grant of withholding of removal, the government knows, or at least should know, that the grant of withholding prevents the Attorney General from removing the non-citizen to the country specified in the withholding order. Okay, so that's a long way of saying it's like, if the order says don't take him to El Salvador, then don't take him to El Salvador. Saying, as the government readily admits, he was granted withholding of removal from El Salvador. And the government had procedural mechanisms to talk about the withholding protection. And the government, it says, did not do that. And they put in a footnote, the government appearing before the court said, well, the order of removal is not part of the record in this case. So there is an order, but I've not given it to you. And the order that we're relying on is not from 2019. So like they're flexing here. Like, nope, we got an order, the executive branch, we're making these decisions. We don't have to run it by you. They're gone. You don't need it. There's no dispute that the order could not be used to send him to El Salvador, the other order of removal. So they're going back in the transcripts. Now, what's interesting is based on those facts. Yeah. So here's what's interesting. Last week, we read through the transcript a little bit from, I think it was from the excerpts from the proceeding that was taking place from Margot Cleveland or perhaps from Kyle Cheney. Read through the transcripts. And in those transcripts, one of these attorneys was getting pretty lippy. I'm sitting here going, you represent Trump? Certainly doesn't sound like it. Says here, of note, the government attorney, the attorney who was speaking all of this has now been put on administrative leave, which is the right thing to do, for lack of zealous advocacy. All right, the DOJ attorney who was saying that Trump was doing a terrible job in court is now gone. Bye. Yeah, and that happened quickly, as it should have. So this attorney, this judge is referencing, is not, basically got fired for not doing a good job of representing the administration appropriately. You can't just say whatever you want. You got to represent your client's position. So during the hearing, the attorney for the DOJ was like, I don't know, those aren't good details for us. The person, the plaintiff, should not have been removed. That's not in dispute, okay? And that is not right. Like, they should have been removed, but not to El Salvador. That is the wrong answer from the DOJ lawyer who is now gone. Now, as such, the decision to remove Abrego was not one within Pam Bondi's decision. The removal was not the enforcement of a valid order of removal. Instead, it was a violation of another law. And because removing him was not an action undertaken with Pam's discretion, we have jurisdiction. And so we think it is lawful for the order forcing him to come back to remain in effect. So the Court of Appeals continues. Now, Trump said that this is an intrusion into the executive branch. But what the government fails to acknowledge, writes the Court of Appeals, who just got obliterated by the Supreme Court and just got stayed, even though they're ranting right here, is that just as the province of the executive to undertake constitutional duties is within the executive branch, so too does the court. So if you have an obligation, so do we. In any event, the government's argument that the Judge Zinnes order improperly directs Trump to engage in international affairs is inaccurate. She's not telling you how to run your country. She's not acting like the president. They write, the government avers that it no longer has authority over Abrego. But as Judge Judge Zinnes explained the government has not provided any evidence to that. The court, Judge Zinnes asked, can we talk about then, just very practically, why can't the United States get Mr. Abrego Garcia back? Fired DOJ lawyer or, on leave says, Your Honor, I will say for the court's awareness that when this case landed on my desk, this dude's gone. The first thing I did was ask my clients that very question, Your Honor. I've not received to date an answer that I find satisfactory. Okay, so this goofball, Ruvini, is now scolding, now siding with the judge against his employer, the DOJ. I asked them that too. I don't know why they didn't bring him back, Judge. Nayib Bukele's the president of El Salvador. He's even saying he has control of these people. So considering these facts and considering that Trump hasn't shown they don't have control, it's just a naked assertion from Trump to say you have no jurisdiction over this jail. Clearly, the record demonstrates otherwise. There's no indication that Abrego Garcia has been charged with a crime in El Salvador or that he's being held there pursuant to their laws. So if he's only being held according to U.S. laws and not El Salvador laws, bring him back. On the contrary, he's a detainee of the U.S. government, only being housed there temporarily, pending the termination of the contract. And so we're not demanding anything of a foreign sovereign. It's just like, it's your rental. It's like your storage facility. You stored him over there, so you got the key, go get him. Now, the government's claim that it can remove an individual from the United States pursuant to such an agreement and then lose the ability to reclaim that person cannot stand. The government's actions in this case violate the Fifth Amendment. See what the Supreme Court says. The government cannot escape its responsibility to return the United States by saying we lack control over El Salvador. And the district court's injunction requires no such thing. And I think a lot of this is kind of beside the point. Like, it's like the weakest argument that they have no control or they can't influence leverage on them. It's a control thing for them, right? I think Trump's position, truthfully, is more like, we don't care if we have control or not. Like, he's not coming back. You have no authority. You have no authority to make us interface with that authority. That's the authority. But they're spending all this time like, well, I mean, like, of course Trump could call Nayib and he'd get the dude out. The injunction requires only that the United States exercise the authority and control it must have retained over the detainees. Requiring that the government facilitate his return is not novel. The government does this all the time. So this is nothing less than exercising our duty to uphold the separation of powers, they say, right? You stepped outside, not us. So you can't now turn around and claim we have no jurisdiction. And there is no harm at all if you bring him back. To get a stay, you must show there's irreparable harm. But you haven't shown that bringing him back is going to have any harm because you even admit he should not have been removed in the first place, which again is not the full story. And they know that. Should not have been removed to El Salvador. But any other country would have been fair game based on the order of withholding of removal, which was only for El Salvador because his pupusas were under attack. This failure alone is fatal, right? The Court of Appeals. And finally, I turn to the government's assertion that the public interest favors a stay because he's a prominent member of MS-13 and he's no longer eligible for withholding relief because there's a new sheriff in town. They say, well, whatever the merits of the determination of the immigration judge about his connection to MS-13, weird. I thought these dumb judges just said that there was no due process here at all. Are we reading the same document? On page 1, they said without any due process. Oh, well, there's a due process right there. An immigration judge just determined that he was a member of MS-13. But the government in this case presented no evidence to Judge Zinnes to connect him to MS-13 again, right? In other words, Trump didn't prove their case again. They got to come back and do it again. The immigration judge was a moron. They have to redo it. So indeed, such a fact cannot be gleaned from this record, which shows Abrego Garcia has no criminal history other than breaking and entering into our country, in this country or anywhere else, and that Abrego Garcia is gainfully employed man who lives as a law-abiding and productive life, right? And that's really nice. You can do that all in his home country of El Salvador. It's a nice place now. Tellingly, the government abandoned its position that Abrego was a danger to the community at the hearing. The balance of equities must tip in the movement's favor based on the record before it. And therefore, an unsupported and then an abandoned assertion that he's a member of a gang, we'll see what they say, because they just appealed this to the Supreme Court and the Supreme Court came back in. I'm not so sure that they're abandoning that, judges. Does not tip the scales in favor of removal. If the government wanted to prove that he was a prominent member, you could have done that. But it didn't even bother to try because it's not the right jurisdiction. They don't have to play your little facade in Maryland. If he wants to contest this in immigration court or file habeas somewhere else, then they can do that and they can have a hearing on this. But from the government's perspective, he got his hearing. From Trump's perspective, he got his due process. They say that even the evidence that he was MS-13 was thin to say the least. The government's claim was based on the fact that he was wearing a Chicago Bulls hat and hoodie. Okay. A vague, uncorroborated allegation from a confidential informant claiming he belonged to MS-13's Western Clique in New York, which is a place he never lived, right? So maybe the informant's bad. Now, of note, the IG's decision, which granted withholding because he faced threats, was during Trump's term. I don't know why that's notable at all, because that judge's decisions were to hold him non-bondable. Now, the government argument that there was a public interest interest in removing members of violent transnational gangs from this country is no doubt true, all right, but it does not help the government's case here. As noted, the government has made no effort to demonstrate that he is a member of a gang, other than just terminating its withholding protection. The government may not rely on its own failure to circumvent its own ruling that he could not be removed and gain a benefit from that. More importantly, they can't be permitted to ignore the Fifth Amendment, to deny due process of law, to remove anyone it wants simply because it claims the victims of its lawlessness are members of a gang, nor can the government be permitted to disclaim any ability to return those. This is a slippery and dangerous constitutional slope. If no due process is of no moment, what is stopping the government from refusing to return a lawful permanent resident or even a natural-born citizen? First they came for the illegals, then they came for the lawful permanent residents, and then they came for us. Contrary to the government's position, upholding constitutional rights surely serves public interest. Yeah, sure. And it says, my good colleague believes that I view this case as a simple one, but I do not. It's straightforward. The government screwed up. They even admitted it, so now they have to fix it. So it is all denied. Now, there was another concurring opinion from another judge, from Wilkinson. I would deny. He concurs in denial of a stay. What we deal with here is what I hope is an extraordinary circumstance. And I think it legitimate to require the district court to facilitate this. And there's no question the government screwed up here, they say. Abrego was subject to withholding. The withholding of removal was country specific. It banned the government from taking him to El Salvador only, citing the law. The attorney general may not remove an alien to a country if the attorney general decides that the alien's life or freedom would be threatened in that country. Okay, but the determination from Pam is that that is not the case. Thus, the government here took the only action on which it was expressly prohibited, and they concede it was an error. And so much debate is centered around this. We're going to keep our eye on this one. Of course, this is Judge Zinnes, who is the originator of this. We're going to have more motions filing in here very soon. Thank you for subscribing and following along as we continue covering this case.